First of all, good afternoon, everybody. Thank you for coming and joining us this afternoon for I guess this is the third in our webinar series. My name is Marc Misthal. I am a shareholder with Gottlieb, Rackman and Reisman. We are an intellectual property boutique. We actually just celebrated our 50th anniversary last month. And we've been running a series of webinars. This is the third. There are two more coming up in the next couple of weeks. You can sign up for those on our webpage if you're interested. A couple of housekeeping things. We are recording this presentation. So if anybody does not want to be recorded or does not want their face recorded, just turn off your video. But we wanted to disclose that, make sure everybody was okay with it before we did it. We'll probably wind up posting this on our website, just so everybody knows. In terms of the presentation itself, I really want to try and keep this casual. So please feel free to interject with questions as we're going along. You can type them to me in the chat. I will try and see them. And if I see them, I will certainly answer them. You're welcome to unmute yourselves and interject if you're more comfortable, whichever works. I'm certainly happy to answer questions as we're going along. It's hard, I think, for a lot of people to speak without stopping and without taking breaks and without getting questions. I think while I have things that are prepared, that I'm prepared to say, and I can go on for a while, I think it's much more interesting if we get the questions and can answer and address those questions. My wife is always amazed that people want to actually listen to me speak for any long length of time. So definitely feel free to interject as we progress. And with that, I guess we will start. And I guess, Kendall, we should start with the slides.
Let's do it. Maybe if I can get the right slide. Let's see, sorry about that.
No problem.
Okay, is it showing the screen, the PowerPoint?
It's just showing the Zoom.
Oh, okay, sorry about that. Here we are.
There we go. Okay, so discussion today is going to be about IP issues to avoid in online advertising and social media. With everybody working from home and pivoting, which seems to be the word of the moment, to online due to COVID, it seemed like an area that maybe didn't get as much focus as, or that's getting more focus than it has in the past, and it's liable to result in more issues than there have been. So we thought it was a good place to talk and point out some possible issues and things to avoid. So the way this is structured, it's really just a series of tips. Hopefully they're succinct enough for everybody to take something away. And let's jump right into it with our first tip. All right, this one's kind of one of my favorite. Just because it's online doesn't mean it's okay to use it. and we struggle with this all the time, whether it's photographs or music or text. There's a tendency among people to think that because something is online, it's available for use for free. That's certainly not the case, and assuming that something is for free is a good way to get into some trouble. We were talking about photography right before this started. Uh, Photographs are actually an area where this has been a tremendous issue, um, and specifically with the unauthorized use of photographs on websites and social media. Uh, I saw last week actually that a law firm got sued for using a photograph on its website without authorization from the photographer. So, this is something that happens. It happens to everybody, um, no matter how big, how small, or who you are. Um, and in fact, it's the other reason it's significant is because over the past few years, the vast majority of copyright infringement cases that have been filed in the United States have been over improper use of photographs. Um, so this is really something uh, to watch out for and be careful about. And this usually comes up in one of two ways. The first way is you're designing a website, your web designer puts up a photograph, you use it, you like it, it's there. And at some point after the website goes live, you get an email like the following. Um, this is an actual message that one of our clients received on a matter. It's from a photo agency, and they had discovered a photo on our client's website that was there without authorization, and they sent this email basically saying, we see that you're using this without authorization. We'd like to resolve this. Contact us so we can arrange for a paid license. And take things from there. This is kind of a non-aggressive way to approach it, but they do monitor. Um, you know, Things on the internet have a way of coming out, so nobody should think that if they're using something without permission, that nobody's going to find out. The internet, things on the internet get found out. What wound up happening in this particular case was client got this email with us, hired us, and was really insistent that they had done nothing wrong. And we said, look, we can negotiate this, but we should make it go away. It's not that big a deal, and they weren't asking for all that much money. And so we were able to negotiate it down, but the amount that we negotiated it down was outweighed by the attorney's fees because the numbers we were talking about were so low. So it really became a wash in the end. But the point here is, if you get a message like this, don't ignore it, because they will follow up and they will sue if necessary. Address it, deal with it, and move on. It's not worth the time or the energy to fight, unless you have a legitimate license. There are plenty of websites out there that have royalty-free images. The image behind me is one such image that we used for our background. If you can't speak today. If you Google them, you will find them, and you're certainly free to use those images. The other way that this image comes up is on the other way this issue comes up is on social media. Um, and here we have an example from a case where a photographer named Justin Goldman took a photograph of Tom Brady and a few other people on the street back in 2016. They were out in East Hampton, and Tom Brady was trying to help the Celtics recruit Kevin Durant. And he took this picture and he uploaded it to, I think he uploaded it to Snapchat, and somehow it wound up getting onto Twitter. And eventually various news outlets embedded the image on their page. And embedding, for those who don't know, really takes the photograph and puts it onto in this case, the news agency's page, making it look like it's right there in the midst of the page. It's the photograph and the comments below it. So that's what happened. The photographer found out and said, "This is all being done without my permission," and filed a lawsuit against the various news agencies, including Breitbart and Time and some others. And what happened here is, he said the photograph was being hosted on Twitter's servers. And the photographer said, "Look, it doesn't matter where the photograph is being hosted, it's being displayed, and that is a violation of one of the exclusive rights granted by the Copyright Act." And that went against the weight of the case law at the time. A lot of the case law said it's in order for there to be an infringement, the photograph has to be hosted on your website. If it's hosted on somebody else's, it's not an infringement. But the photographer pursued the case, and the district court here in New York, ultimately ruled that this was an infringement. Went against the existing case law and said, yeah, this is an infringement because it violates that display right. The news publications were not too happy about this. The case went up on appeal. The Second Circuit said, we're not really going to touch this because it hadn't been fully litigated yet. And the parties eventually settled. So there's no ruling contradicting this, and that ruling that this was an infringement still stands. Now, the court, in making that ruling, didn't rule on all the issues in the case. Did not address various defenses, including fair use, and whether or not it was covered by the terms of service. But those issues were left for another day. What happened afterward is Instagram eventually came out and said, pictures that are posted on Instagram are not available for third parties to use. You can't just use them. You have to get a license from the owner of the rights to the photograph. And this has kind of put things into a tizzy, because the web is kind of freewheeling and everybody likes to link to things and post things and share things, and having to get permission does not really help or make those things possible. But there have been some recent cases that address it somewhat. There was a case earlier this year where court said that under Instagram's terms of service, posting a photograph does make it available to others for use. And it was after that decision that Instagram came out and said, no, it doesn't. Um, and in fact, I saw a decision which I haven't had a chance to read in full yet, just yesterday, that came out and said the court there found fair use and excused the infringement. That was also a case involving news publications, so that won't necessarily apply to everyone. Um, but what it shows is that there's the potential for trouble here. And the reason there's really some potential for trouble here is the damages that are available. Briefly, for those who don't know, for copyright infringement, copyright owners, as a general matter, can recover statutory damages, which in certain cases can go up to $150,000. And in certain cases, they can recover their attorney's fees. Those two numbers can add up. Certainly, most people don't like to pay one attorney, much less two. And those things can often be used to force a settlement and bring everybody to settle. So there really is can be some significant exposure in these cases. The other thing to be aware of before we get to hashtags is that social media in general has policies for taking things down. So if you find an infringement on Amazon or Instagram or Facebook, if you dig around, and it does take some digging, they usually have policies that can be taken advantage of in order to take things down. And they're usually pretty good about doing that. So that's something to keep in mind. The problem is if you're the person that posted it and you start getting a lot of complaints, that can affect your ability, for example, on Amazon to do business. If they get enough complaints, they will shut your account. So it's something to think about and be careful about. So talking about social media, that brings us to a different area, something a little bit different from photographs, which are hashtags. And just so everybody's on the same page, hashtags are a means of identifying the subject of a particular message or a photograph that are when they're posted on social media. And it typically takes the form of the pound sign followed by some kind of descriptive word or phrase. And the difficulty here is not to use hashtags that suggest an association with somebody else. And there's I have a good example if we get to the next slide. This is from a case that is actually still pending in the Southern District of New York. It's been dragging on, at least in part due to COVID. But in this case, Chanel sued a company called What Goes Around Comes Around, which was offering, was offering used Chanel product on their website. And they even offered certificates of authenticity. And one of the things that What Goes Around Comes Around was doing, it's a little bit hard to see, but if you look at the red circle on the slide, you can see there's a hashtag WGACA Chanel. And when Chanel brought the lawsuit, one of their several claims was that because of those hashtags, people would think that there was some kind of association or some kind of endorsement by Chanel of What Goes Around Comes Around. What Goes Around Comes Around filed a motion to dismiss that claim. And the court said, no, we're not going to dismiss it. So that claim is at least viable. The court recognizes that there's a possibility that there's liability there. There has not yet been a ruling on this, So we don't know if the court will actually find liability because of it. So we're waiting to see what happens with that. But again, this is an area that should be pretty easy to control, and to be careful with hashtags that are being used on social media postings. I can tell you that I saw a separate case also involving a handbag manufacturer uh, where they were also objecting in the context of a cease and desist letter to use of certain hashtags. So it's definitely something that people are looking at and policing. So something else to think about and be careful about as you're out there on social media. I think that brings us to our next tip. Okay. Okay. For this one, we don't really have any nice pictures. It's simply the tip, which is pretty straightforward. Own your own brand. What does that mean? That means if you have somebody else do something for you, design a logo, take a photograph, create content, make sure that you have them sign something transferring all the rights to your company. Don't want to be in a situation where you don't have that piece of paper and whoever you've hired comes back 3 or 4 years later and says, great, you're doing terrific. I created that for you and you owe me some money, and your business is doing gangbusters, so you can afford to pay me. Nobody likes to do that when they hire somebody. Nobody likes to have that piece of paper signed because it just doesn't seem right. It doesn't sit well. Trust me, you want that piece of paper signed. A few years back, we were involved in a lawsuit where one of our clients hired an outside artist to design a product for them. Client was very about getting the documents all signed off. For whatever reason, they didn't get a sign off on one particular product. They released the product. Product did well. And then they heard from the artist saying, I never signed anything. I own this. You owe me some money. And that was the start of about a year and a half worth of litigation. It was ultimately settled. I was happy to be involved because, attorneys like handling litigations, but nobody else ever really likes being involved in them. So one way to stay out of them is to make sure that you own everything. And we can certainly help with preparing those documents if anybody needs that help. Okay, tip number 4 is something we're calling Zoom fringing. And it's something that we should stay away from. A good example of it would be the next slide. So Zoom backgrounds are popular. I mean, I'm using one right now. I can see from my window here that other people are using them as well. It might be fun to have Vincent Vega in your background. I'm not sure that John Travolta or Quentin Tarantino would really agree or approve of that. Okay, and I got a note that we might have some questions. Does anybody have a question before I go on? I don't see any. Okay, I don't see any, so I'm going to continue, but if somebody does have a question, feel free. Again, the issue here is you don't want to use this at a corporate event and face some kind of claim that there's some kind of false endorsement or false association, because that's just going to lead to trouble. And we have seen those types of claims. They do get made. I don't want to delve into politics, but a good example of those claims is certainly during the election. We have, I'm sure we've all heard of various musicians who have objected to their music being used by one candidate or another. Um, One of the aspects of those claims is that there's some kind of false endorsement or false association between the musician and the candidate. Um, so it's best to not not use these type of backgrounds. Certainly on something that you're doing that's corporate, you can probably get away with it on something personal. Just to give another example, and we can take a look at the next slide. These are just things that I found out there for fans of Seinfeld. You can find pretty much anything if you're looking for it. Last one should be recognizable to a lot of people. I believe this one was actually put out by Fox and is a legitimate background. You still might want to avoid using it in some kind of corporate or company situation because you don't want anybody thinking that The Simpsons is sponsoring or endorsing you. That will bring us to our next tip, which very straightforward. Celebrities don't do things for free. It's just a fact. They don't. And the example we've got. Whoops! I think we lost our slides, which I'm sure we'll get back. There we go. So if we go to the next slide, we can take a look at the example on this, and I can explain a little bit about what was going on here. This is from a case that was filed actually in April this year in California State Court in Los Angeles. It's still pending. But what happened here was a third party whose name I forget made a video game, an app that you could download for your devices. And the concept of the game was you can be a celebrity. You can be, in this case, Selena Gomez. They have a bunch of other celebrities. And the game was you can dress the celebrity, you can date other celebrities. Basically, you could live your fantasy and be a celebrity. And the image on the left is an image from the game that was being used. And Selena Gomez found out about this and objected by suing. And it's, to me at least, it's pretty clear where that image came from because it looks to me like it's literally the mirror image of the image on the right. So, she found out about this, filed a lawsuit. I see a question.
Yeah. Hey, Mark, can you hear me?
Yes.
Okay. So my question on this stuff with regard to Zoom. So in this case,
Yep.
Gomez, they were using it in a game. So it's really for commercial purposes. They're making money using an image that they're not authorized to use. But in the case where somebody might use, you showed that John Travolta slide before, if they just use that, or the Simpsons living room in their Zoom presentation, there's probably not, I mean, I know an attorney, you'd say you're better off not using it, but there's really little harm in using that in a local Zoom presentation that you're doing for a chamber of commerce or a library, because there's no commercialization of it and it really doesn't have, much in terms of legs, and it's not really going to go very far. Is that right?
It's a question of degree, right? And I started off by saying that anything on the internet, I would never assume that it's not going to be found, because things get found. Things on the internet get found. If you know that it's going to be a very limited audience and it's not being circulated and it's not being posted on the internet, yeah, you might be able to get away with doing it without getting a letter from somebody. But if somebody finds out, they're going to, there's a good chance that they'll send a letter. To go back to the example of the musicians, well, maybe that's not such a great, not the best example. The fact that it's not commercialized does not necessarily immunize anything. It doesn't mean that there's no violation. It doesn't mean you're not going to hear from somebody. What it means is that the damages may be minimal. It depends exactly what we're talking about. If there's a copyright claim in there somehow, which could be the case with the photograph from Pulp Fiction, it wouldn't even matter, because then they could get statutory damages. So the answer is, yeah, you might be able to get away with it. There's risk, and look, there's risk in doing everything. There's risk when you get out of bed in the morning. But the more publicized and the further out and the more distributed it's going to be, the more risk you're taking. There are some other factors that that could be important. How much is taken, how long it's on the screen for, et cetera, et cetera. But nobody likes getting those letters from lawyers. I mean, we like sending them, but nobody likes getting them. So probably best to stay away as much as possible.
Mark, could I raise a question? Yeah,
Sure,
this brings up the issue with Tom Brady and the photograph. And constantly I hear fair use. And obviously in that case, I don't think it was a commercial purpose. I think it's more equivalent to newsworthy. I understand the copyright aspect to it, but how serious, in your opinion, would be an infringement of that nature? Because it's social media, it doesn't have any, it's not like a video game that that a celebrity will make money with it.
Right. And in the Tom Brady case, the court never got to the fair use issue. It was never addressed. I think that was probably a good argument, because it was newsworthy, and it was being used for news purposes, and that's oftentimes considered to be a fair use. And the case, and again, I haven't had a chance to read it, but I saw it just yesterday. There was another case involving a photograph where the court found that it was a fair use.
Right. Mm-hmm.
So I have to take it, get a few minutes to read that decision. The problem with fair use is that it's not a hard and fast rule, and that it's very fact dependent. So I'm always reluctant to rely at least exclusively on fair use as a defense, because you never know how it's going to come out. One court can see it as a fair use, and on the same facts, another court may find it that it's not a fair use. It's very, very fact dependent, and it's to some extent subjective. So yeah, you can argue it and go from there, but fair use makes me nervous, just because there's no certainty.
Okay.
Are there any other questions?
Wow.
Does anybody have anything else before I resume or continue? I do have one last thing to add. It's not something that we have a slide for, but all of this begs the question of how do you stay out of trouble? And certainly what I found from looking at these different issues and just practice in general, it's really a question of using common sense. If you wouldn't want somebody using your thing in a particular way, it's probably a fair guess that they wouldn't want you using it in that way either. It's really abide by the golden rule, do unto others as you would have do to them, do to you. Boy, it's been one of those days. That really is, to me at least, the best the best way to handle this. And I'm seeing a comment about the Mel Gibson matter in Chile with honey. That was very interesting. You also get, there's a whole host of issues when you get to celebrities. One that came up in that case was whether Mel Gibson should have really been going after what was a small business. There were certainly people who said, he should have just left them alone. Another question that comes up is celebrities' right of publicity. In these photograph cases that we've been talking about, they oftentimes involve models, and the models have several models have come out and said, owning a picture of me is somehow wrong because I lose control over myself. There have definitely been a couple of models who have come out and written fairly extensive pieces that have appeared in the press about that. So there, there's a whole host of issues, but really the question in my mind, the way to stay out of trouble is, really think about it before you do it. And if you're not sure, go and ask somebody. Ask your lawyer. Come ask us. But if you don't ask us, ask another lawyer. It's better. Many times, it's better to ask the question and stay out of trouble and avoid a big issue than to just go ahead and do it and find yourself embroiled in some kind of lawsuit or other type of dispute. With that, if there are any questions about anything we've spoken about, something that's on somebody's mind, happy to entertain them. Did I put everybody to sleep? Okay. All right. Well, hopefully everybody is at least still awake, and if you're asleep, it's because you were up late last night and not because of me. I would just remind everybody that we do have 2 more webinars in our series coming up in the next couple of weeks. Again, if you're interested, you can go onto our website, www.grr.com, and you can sign up there. I just want to thank everybody for coming and participating and listening to me. I want to thank Kendall for her help in putting this together and running the slides. And otherwise, that's it. If there are no more questions, I guess we'll call it a day.